Good day, Crime Talk aficionados. We have a great show and a lot of information to get to you today, so let's get to it. First, a jury acquits the former Uvalde school police officer for not doing his job. Actor Timothy Busfield was released from detention and then goes off to a luxury resort. Court grants defense access to sealed documents in the high-profile murder case. Families of the Idaho stabbing victims condemn the accidental disclosure of crime scene images. A former battalion chief convicted of murder. New Jersey landlord indicted for multiple charges for alleged assaults on tenants. We've got This Day in Legal History, our quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and remember, you can check us out on any of your favorite podcasting apps. Before we get to today's docket, let me remind you to go to crimetalkprep.com. Go there, and guess what? When you purchase a 3-month emergency supply of food, you're going to get $400 worth of gear that comes with it. Remember, in today's world of political uncertainty, natural disasters, they're talking about a natural storm coming in the next couple of days that's supposedly going to shut everybody down in the South, a big old ice storm. Listen, ladies and gentlemen, if you haven't made your way to the store already, what are you going to do if the stores are closed or if there's a run on everything? You need to be able to take care of yourself. Go get your emergency food supply today. And when you sign up, you're going to get $400 worth of free gear. Go to crimetalkprep.com. You're going to be happy that you did. All right, let's go ahead and open the record for Thursday, January 22nd, 2026. And first on the docket, a jury acquits the former Uvalde school police officer in the Robb elementary shooting case. That's right. A Texas jury has acquitted Adrian Gonzales, the former police officer with the Uvalde Consolidated Independent School District, of all charges related to his actions or inactions during the 2022 Robb elementary school shooting. The verdict, delivered last night, clears Gonzales of 29 counts of child abandonment and endangerment stemming from the tragic event that resulted in the deaths of 19 students and 2 teachers. The jury reached its decision after approximately 7 hours of deliberations in a trial held in Texas following the defense's successful motion to relocate the proceedings from Uvalde County due to concerns about community bias. Now, Gonzales, who's 52 and a 10-year veteran in law enforcement, faced potential imprisonment of up to 2 years per count, each charge corresponding to the 19 children killed and 10 injured survivors in the massacre perpetrated by then 18-year-old Salvador Ramos back on May 24th of 2022. Now, the prosecutors, led by Special Prosecutor Bill Turner, appointed by the Uvalde County District Attorney Christina Mitchell, argued that Gonzales failed to adhere to his training protocols. And as the instructor of an active shooter response course conducted just 2 months prior to the incident, Gonzales was accused of not intervening to prevent Ramos from entering the school building. Now, over the course of the 2-week trial, the prosecution presented testimony from witnesses who described the scene's devastation, supplemented by graphic photographic evidence. Now, Gonzales did not testify in his own defense. His legal team, headed by Nico LaHood and included attorneys Jason Gross and Gary Hiller, contended that Gonzales acted courageously amid the chaos. They emphasized body cam footage showing him as one of the initial responders entering a hazardous smoke-filled hallway in the attempt to confront the assailant. Gonzales did not observe the gunman and noted that other officers present failed to engage Ramos while he remained outside the school. They argued that a conviction would impose an unrealistic standard of perfection on law enforcement during crisis, potentially deterring decisive action in future emergencies. In closing arguments, the prosecutors appealed to the jury to hold Gonzales accountable as a means of reinforcing officers' obligations to protect vulnerable vulnerable individuals, particularly children in active threat scenarios. Now, the defense countered by portraying Gonzales as a dedicated officer who risked his life in what they described as a hallway to death where others hesitated. Following the acquittal, Gonzales addressed reporters, expressing gratitude to divine providence, his family, his spouse, and his legal counsel. He commended the jury for their thorough review of the evidence, but declined to offer immediate comments to the families of the victims. Now, LaHood, the attorney, elaborated on the defense strategy, which spanned from jury selection to evidence presentation and final statements, leveraging prosecution witnesses to underscore key points. Now, Gonzales and former Uvalde police chief Peter Arredondo were the only two officers criminally charged in connection with the delayed response to the shooting, which has drawn obviously a lot of scrutiny for law enforcement's handling of the crisis. Now, Arredondo faces 10 similar counts of child endangerment with his trial yet to be determined. Presiding over the case was a judge by the name of Sid Harrell. Now, the prosecution anticipated calling up to 60 witnesses, including medical examiners, responding officers, and healthcare professionals and relatives of the victims, though only 36 testified. Now, conviction on these state charges obviously could have resulted in a lengthy sentence, but obviously they will not now because he was acquitted. Obviously, big debate on accountability in these mass shooting type of situations. And, we'll see how these proceedings are going to affect the Arredondo trial. If the prosecutor was smart, they should dismiss the case against the police chief as well. This police officer, you may not like his conduct or you think he should be held responsible, but the reality of it is jurors may have looked at this and said, what would you have done under the same circumstances? Most people would be running the other way. This guy stayed, maybe didn't like exactly what he did, but it does set a dangerous precedent. Now, we talked about this when this trial was starting, that, there's case law out there, established precedent, that you can't sue the government for not responding, quick enough to your 911 call. So I was a little surprised that this actually made it to a jury, but the jury clearly rejected this, and this Corpus Christi jury, obviously not an Uvalde jury, which probably would have convicted the officer, looked at this and said, this is just a bridge too far. We can't go there. And I get it, mass shooting, something like that. Everybody wants to hold somebody accountable. But the person that's responsible in this particular case, the shooter, he's dead. Okay? And I get you want somebody held accountable, but this is not the way to do it. Next, Timothy Busfield. Well, he's out on bond. That's right. We brought you the story yesterday. Timothy Busfield, the actor known for his roles in television and movies, marked his initial hours of release from custody with a change into civilian attire and a visit to a local grocery store, including a Citarella and Trader Joe's, according to people that saw Mr. Busfield scattering around town. Anyway, Busfield was released from the Metropolitan Detention Center in Albuquerque, New Mexico on Tuesday, following a 7-day detention period. He had been placed in the facility's restrictive housing unit, a segregated area designed for and designated for individuals needing heightened security measures, after voluntarily surrendering to the police on January 13th in connection to the allegations of child sexual molestation. Now, once Busfield left, he left with his wife, and they went to a high-end short-term rental property in Albuquerque, a little bit of an upgrade from his conditions at the detention center. This place is, the detention, so 5 a.m. wake up, apparently. Anyway, Busfield appeared in good spirits as he exited a white 4Runner at the Via de Rafael, an opulent Italian-inspired estate secured by his wife, Melissa Gilbert. And don't worry, it's only $2,400 per night with a minimum 3-night stay. At least you know his attorneys are going to get paid handsomely. Anyway, the 6-bedroom residence situated on an acre of manicured grounds features 7 bathrooms, a hot tub, a separate guest castilla in the rear, a striking stained glass dome, premium linens, a gas barbecue, and an extensive library, as well as a game room. So at least he's comfortable. Anyway, Melissa Gilbert, Busfield's spouse and former star of Little House on the Prairie, was observed at the properties early Wednesday morning, dressed in sleepwear while handling household waste disposal. i.e. taking out the trash. Anyway, Gilbert has remained steadfast in her support amid these serious accusations. She attended the court appearance on Tuesday, obviously accompanied by legal counsel as well. Gilbert presented a letter to the court for them to consider when making the decision as it relates to bond, and wherein she described Busfield as her unwavering companion, emphasizing his moral integrity, dedication to helping others, and his role as the central figure in their blended family. She highlighted their deep mutual understanding and pleaded for his well-being. Now, during the proceedings, prosecutors argued for continued detention, citing potential risk to the community, while the defense countered that the charges had resulted in professional repercussions, diminishing any perceived influence Busfield might hold. Gilbert later expressed gratitude for the encouragement directed towards her husband. Obviously, big case. You got a celebrity accused of doing allegedly horrible things to children, even if it is just a groping. But the reality is the case will have to move forward, and the truth, or a pretty darn close version, will hopefully come out, and justice will be served. Now, obviously, these allegations stem from an incident purportedly occurring during Busfield's involvement in the production of The Cleaning Lady, involving claims of misconduct toward 11-year-old twin boys. News of the arrest warrant surfaced about January 9th, prompting Busfield to travel to New Mexico from New York, where he turned himself in. He's entered a plea of not guilty at his initial court appearance and on January 14th, and he has publicly refuted the accusations, expressing profound distress over these allegations. His legal team has suggested that the claims may represent an attempt of extortion following the conclusion of the minor's participation in that video or television project. Now, like I said, Busfield will remain free on his own recognizance, with both he and Gilbert navigating the fallout from these developments. Next on the docket, getting access to some information, a high-profile murder case. That's right. Let's go to Lompoc, California. So in recent developments in the criminal proceedings against Ashley Buzzard, a 40-year-old resident of Vandenberg Village, accused of murder of her 9-year-old daughter, a Santa Barbara County Superior Court judge has authorized the defense team's access to sealed search warrants and related affidavits. This ruling, issued during a hearing on January 21st, also extends to any forthcoming sealed warrants in the case. Now, the judge presided over the session there in Lompoc, where he also upheld a permanent gag order that will remain in place throughout the trial. The order restricts the sheriff's office from disclosing further investigative details following a defense motion aimed at safeguarding the integrity of the proceedings. And representatives from the county, their attorneys and prosecution indicate that they held no stance on the gag order request. Now, as you may recall, Buzzard faces charges stemming from an incident back in October of 2025, which she allegedly shot her daughter, 9-year-old Melody, several times in the head and abandoned her body in a remote section of Wayne County, Utah, amid a multi-day road trip. Police initiated a missing persons inquiry back in October of last year, following reports from the school officials about the child's prolonged absence. Officials noted that Buzzard's lack of cooperation throughout the investigation, which spanned several months. And the case advanced significantly on December 23rd when human remains were located and subsequent DNA analysis confirmed the identity of Melody, leading to Buzzard's arrest. Court documents from an earlier search of her residence revealed the seizure of various electronic devices, obviously underscoring that there's some further forensic analysis going on. And during the January 21st hearing, Buzzard's public defender successfully argued for the release of these sealed materials. Additionally, at the defense's behest, Buzzard agreed to waive her right to a speedy trial, postponing the proceedings until at least April of this year. Now, the extension delays the preliminary hearing, as the public defender highlighted a substantial shortfall in providing discovery material, particularly the forensic evidence. The public defender also elaborated on the issue, stating that the absent documentation could encompass hundreds or even thousands of pages. And she emphasized the defense reliance on assurances from the sheriff's office regarding the existence of such evidence, questioning the prolonged delay in its delivery. In fact, the attorney said, "We have been informed through official statements that this material is available and that the extended wait raises legitimate concerns about the pace of the process, though they remain committed to a thorough review once they finally receive it." Anyway, the court scheduled the next court appearance for February 11th, 2026 to assess the progress on the outstanding discovery delays. Now, according to people that were in the courtroom, tensions were very evident where Melody's paternal grandmother, Lily Dennis, voiced dissatisfaction with the procedural extensions and perceived leniencies afforded to the defendant. Dennis described the situation as emotionally taxing, particularly in efforts to repatriate the child's remains. As Buzzard departed the courtroom without restraints per a prior request, an onlooker directed a disparaging remark towards her, prompting disruptions noted by attendees. The public defender addressed the public reaction, expressing concern over premature judgments, and it's regrettable to witness such interruptions in a case as serious as this. Our justice system demands patience and impartiality to ensure a fair trial for all parties involved. Now, like I said, Buzzard has entered a plea of not guilty and remains detained without bail at the Northern Branch Jail in Santa Maria. Obviously, big issues in this particular case, jurisdictional issues, since the child was killed in Utah, but California says we're going to handle this because this is where the planning took place, and it's going to, well, let's just say, be interesting to say the least. And you have to be patient. These cases take a long time. And when you're dealing with lots of documents and lots of evidence, the attorneys have to go through it, have to look at it, evaluate it, analyze it, probably get experts to double check it and see what evidence is there and what isn't there. And then you go back and forth. It takes time. Yes, you have to be patient. I understand everybody wants instant justice, but due process takes time. Be patient, ladies and gentlemen. The truth, or a pretty darn close version of it, will come out shortly. Next on the docket, the family in the Idaho murders, they're a little upset. So in a development that has reignited grief and controversy surrounding the 2022 murders of 4 University of Idaho students, that's right, crime scene photographs were inadvertently made public this week, prompting strong condemnation from the victims' families. Now, the images depicting the interior of the off-campus residence in Moscow, Idaho, where the students were fatally stabbed back on November 13th of 2022. They were released without adequate restrictions as detailed in recent court documents. So, as you know, all the victims were attacked in their home there at the 1122 King Road residence, which obviously shocked everybody. While representatives from the Gonzales family described the release as a significant procedural oversight, emphasizing that materials stemming from such a serious crime should be handled with the utmost caution. In a public statement, they urged empathy from the public, stating, "We ask for kindness and though challenges, encouraging others to view the material as if involved their own family members, daughters, sisters, son, or brothers. Homicide is not a form of amusement, and images from a crime scene are not mere media fodder." As you may recall, prior legal efforts by the families aimed to halt the spread of these photographs took place, and a request of a temporary restraining order was submitted back on August 12th and approved by Judge Megan Marshall 3 days later. Subsequently, on October 1st of last year, a permanent injunction was established to prevent additional dissemination of specific evidence. Legal counsel for the city has informed the court that despite any personal reservations about publicizing the images, their obligations are governed by the Idaho Public Records Statute. These laws prioritize transparency with limited exceptions for privacy concerns, positioning the city as an intermediary in the process. To date, the city has disclosed edited versions of body cam recordings and selected interior photographs of the property. Now, the unintended release occurred over 3 years after the arrest of Brian Kohberger, who was obviously charged and pled guilty and is, serving the rest of his life in prison for this. Listen, there's always going to be a tension between public access to information and the victim's family's rights to privacy during legal proceedings. You have to strike a balance to it. The laws in Idaho favor transparency, which all laws should when it comes to information that the government's involved in. I understand it's tragic, and people ask, would you feel the same way if this was your children? And I'd say, yes. Yes, I would. Because you know what? They're going to redact certain things. But the reality of it is, wouldn't you want the world to see the atrocities that Brian Kohberger committed? He is evil. Evil exists. The only way you're going to get people to see how evil he is to see what he did. Transparency. I get it. Here's the thing. It can be made transparent. And you, the public that doesn't want to see the images, doesn't have to look at them. But maybe if you have a legitimate interest in it, you're like, hey, I want to see, does that match up with the story we were told about knives, how it went in, the murder went down? Why shouldn't you be able to study it? Why should you not be able to do it? Now, you should do it tastefully and you should do it respectfully, but it doesn't mean you can't have access to it. That's not the way the laws are written. The government should be transparent in everything that they do. Let me know what you think in the comments below. Next, a former battalion fire chief convicted of murdering his wife. A jury in Clark County, Washington has convicted a retired fire department battalion chief of murdering his wife in a case involving claims of a medical emergency that investigators later determined to be a murder. Kevin West, previously employed by the Camas, Washington Fire Department, was found guilty on January 20th of both first-degree murder and second-degree murder in connection with the death of his 48-year-old wife, Marcy West. The incident occurred back on January 8th of 2024 when West contacted emergency services to report that his wife was experiencing a seizure and had ceased breathing. He stated that he had initiated cardiopulmonary resuscitation. Responding personnel attempted to revive her, but she was declared deceased at the scene. In the subsequent days, law enforcement received multiple reports from individuals expressing suspicions regarding the couple's marital difficulties and questioning whether Marcy's death resulted from natural causes. Well, during the 2-week trial, prosecutors presented evidence that West was engaged in an extramarital relationship at the time and had plans to end his marriage. Defense counsel acknowledged the affair, but contended that Marcy's death stemmed from a seizure triggered by chronic headaches, as reported in the local media. The county medical examiner concluded that the cause of death was asphyxiation accompanied by blunt force injury to the neck, classifying it as a homicide. And testimony from the West's current fiancée, Cynthia Ward, provided insight into their relationship. Ward explained that they had been acquainted for 2 decades with a short-lived intimate involvement in 2024 during West's marriage to Marcy. They resumed contact in 2023, initially in secret while both were committed elsewhere before their connection deepened. Ward indicated that West had intended to eventually separate from Marcy, though without a specified timeline. The couple had 2 grown children. A friend of Marcy, Wendy Chun, expressed relief in the verdict, calling it justice. She noted that the alternative resolution to the marital issue existed without resorting to violence and lamented the impact on the children, who effectively lost both parents due to these circumstances. Well, West's sentencing is scheduled for February 27th. Just get a divorce, people. You don't have to kill anybody. Just get a divorce. It's that simple. It really is. It's money. It can be replaced. You can make more. You don't need to kill anybody. Seriously. Next, a New Jersey landlord indicted for multiple charges of alleged assaults on his tenants. So in a significant development in Burlington County, New Jersey, a 60-year-old property owner has been formally charged with numerous offenses stemming from claims of drugging and then sexually assaulting 2 individuals who resided in his residence. Police have described the incident as occurring over an extended period. Now, the Burlington County prosecutor, Lachia Bradshaw, announced that the defendant, Craig Cardella, faces a total of 72 counts, including 17 for kidnapping, 18 for aggravated criminal sexual contact, 18 for invasion of privacy, 18 for endangering the welfare of another individual, and 1 for stalking. These charges were formally through indictment issued in December, and Cardella entered a plea of not guilty at his most recent arraignment. The case involved 2 male tenants who leased rooms from Cardella, and prosecutors allege that the assaults took place with the home environment, highlighting a breach of trust in a landlord-tenant relationship. Now, the police chief there initiated the investigation back in December of last year. following a report from one of the affected individuals. And according to official accounts, the complainant awoke during the night to discover Cardella in his bed, applying a mask to his face while engaging in inappropriate physical contact. The subsequent execution of his search warrant at the property led to the discovery of some incriminating items in a secure storage unit in Cardella's closet. These included 2 containers of chloroform, prescribed sedatives, surgical masks, a video recording device, and various electronic media storage units. Law officials are pursuing leads to identify if there's any potential other victims. That's weird and creepy, isn't it, ladies and gentlemen? Your landlord coming down, putting a little chloroform on you, and then apparently videotaping the weird sexual acts that he does with you while you're basically passed out or drugged. Weird, creepy. That's like go to prison stuff for a long time. Danger to the community. Wow. Next, this day in legal history, 1946, President Harry Truman issued a presidential directive establishing the Central Intelligence Group, which was the precursor to the CIA. Obviously, the Central Intelligence Agency in the post-World War II era and the foundation of the modern national security structure. There you go. And on this date, in 1973, the United States Supreme Court issued the landmark decision in Roe v. Wade, ruling in a 7-2 vote that the Constitution protected a woman's right to an abortion under the 14th Amendment Due Process Clause. The decision legalized abortion nationwide until it was overruled in 2022, and it went back to the states. We've talked about that before. I remember one of my first law professors in constitutional law said this is completely made up law. It was one of the worst legal decisions ever made, and not for whether you liked or the way they did it, but the court just made it up. Imagine the founding fathers at that particular time saying, you know what? We should probably discuss abortions. No, that's included in the penumbra of the Fourth Amendment. Yeah. Anyway, like I said, whether you like the decision or not like the decision doesn't matter. From a legal standpoint, it was a horribly written decision, completely made up by the judges. On this date, 1998, Theodore Kaczynski, known as the Unabomber, entered a plea of guilty in federal court to charges related to a series of bombings that killed 3 people and injured others over nearly 2 decades. The plea agreement spared him the death penalty, and then he got life imprisonment instead. Next, our legal quote of the day in recognition of the anniversary of Roe v. Wade decision on this date. A pertinent legal quote exemplifies criticism of the ruling as judicial activism. Quote, the upshot is that the people and the legislature of the 50 states are constitutionally disentitled to weigh the relative importance of the continued existence and development of the fetus on the one hand against the spectrum of possible impact on the woman on the other hand. As an exercise of broad judicial power, the court perhaps has authority to do what it does today. In my view, judgment is an improvident and extravagant exercise of the power of the judicial review of the Constitution extends to this court. That was Justin Byron White made his statement in his dissent. Like I said, whether you like it or not, we're not getting political. I'm just saying nowhere in the Constitution does it say that. And if you look at it as a, construction argument, it doesn't exist. And, like I said, now it's back with the states, and let the states decide with it, which is what was originally intended by the founding fathers to deal with those issues that are not specifically mentioned in the United States Constitution. Next, our dumb criminal of the day. In a case that blends winter maintenance with regrettable impulses, a Connecticut snow plow driver has been charged after a routine incident that transformed a routine clearing operation into a chaotic demolition derby. Now, Mark Keene reportedly admitted to police that he had consumed 3 doses of cocaine shortly before losing control, resulting in extensive property damage across multiple residents. The episode unfolded on December 28th, marking Keene's inaugural shift with Bollinger Landscaping. And according to investigative documents, the mishap began following a heated telephone exchange with his partner, prompting him to ingest the controlled substance. Moments later, he experienced a blackout while maneuvering his snowplow, equipped with a front-mounted plow, obviously. Surveillance footage captured the vehicle's erratic path. Its first gazed a residential porch, splintered its railings, then breached a stone barrier, divided adjacent properties. Undeterred, the truck proceeded onto a neighbor's driveway where it collided with a stationary automobile. The impact propelled the car through a garage door, compressing it beneath another vehicle parked inside and lifting the ladder towards a ceiling. A testament to the force involved. Anyway, the total extent of the wreckage spanned approximately 434 feet, encompassing lawns, structures, and cars in what police describe as a prolonged trail of unintended landscaping. Upon arrival, police encountered Keene seated in the truck, seemingly oblivious to the turmoil. He expressed anticipation for colleagues to assist with shoveling duties and denied any awareness of the collision. Police noted his speech was indistinct with constricted pupils, prompting a standard sobriety evaluation. Midway through the assessment, Keene exhibited severe distress, including foaming at the mouth. Emergency people transported him to the hospital. En route, he resisted restraint, injured an officer, threw bites to the hand and arms before eventually stabilizing. Subsequent blood analysis confirmed the presence of cocaine, benzodiazepines, and cannabinoids, aligning with his earlier statement. He surrendered to police on January 8th on a $15,000 bond and got out. He's scheduled again for February 25th. Faces allegations of operating a motor vehicle under the influence and engaging in reckless conduct. Needless to say, Mr. Keene is our dumb criminal of the day. Congratulations, you made it, sir. I got an idea. Obvious, it's not don't do drugs at work. That's obvious. How about next time, if you think you're going to have a fight with your partner, don't take that call. And then don't do drugs at work. How's that? Anyway, Mr. Keene, you are a dumb criminal of the day. Congratulations, you made it. All right, ladies and gentlemen, that's all we have for today. Hope you enjoyed the show. Thanks for watching. We'll see you next time. And remember, the Constitution matters.